There's a really interesting question that's come up in the comments to one of the many videos we've done on this Prince Harry trial. And don't get me wrong, it's not all about Prince Harry. It's about the legal principles that come up in this case that give us, as lawyers that love to help you understand law, the opportunity to explain these legal principles. So this one question has come up, and we've answered it in one specific way on this channel, Art and Media Law. So make sure you subscribe because it's not my normal channel. About journalists and why they are not giving evidence in court, i.e. why they're not being summoned and giving evidence in court because the judge has said no. No, they don't have to come to court, they don't have to give evidence. Now, there's a number of questions here, one of which we've answered in the previous video. I'll link that below. You can see that in full detail. The short version is they don't have to give up their sources, but to understand that more fully, I'll link those videos in the description below. But another question, broadly the same question, but a very slightly different take on the same question, is, and quite an understandable question why someone would ask this question, is why are these people not being summoned to court to be asked directly, did you hack somebody's phone or computer? And it's a very valid question. Why are these journalists not being brought to court to be asked the question directly by the judge or by a lawyer, did you hack this phone? Now, the simple reason is we have a rule in England and Wales, which many, even in England and Wales, might not be familiar with, but certainly in other jurisdictions you may not be familiar with. We have a rule against self-incrimination, and that goes for yourself or your spouse or your civil partner. And that is contained within Section 14 of the Civil Evidence Act of 1968. Which I'll bring up on screen, that provides the right of a person in any legal proceedings other than criminal proceedings to refuse to answer any question or produce any document or thing if to do so would tend to expose that person to proceedings for an offence or for the recovery of a penalty. And this shall apply only as regards to criminal offences under the law of any part of the United Kingdom and penalties provided by such law, and include a right to refuse to answer a question or produce a document or thing if to do so would tend to expose the spouse or civil partner of that person to proceedings for any such criminal offence or the recovery. Safe to say that there are some exceptions which are beyond the scope of this question and this video that relate to the proceeds of crime. For instance, those suspected of having benefited from criminal conduct will obviously be required to provide information in the recovery proceedings, and that can potentially infringe on that right against self-incrimination. But very broadly speaking, this is known as the privilege against incrimination of yourself or your spouse or civil partner. And so aside from the fact that the sources of journalists are protected, there is this right against self-incrimination. And if you were even summoned to court to give evidence and a question were put to you, the judge would most likely intervene and say, just to warn you at this stage that you have the right not to answer that question if you believe that the answer is going to incriminate you. And so this is a broad right against self-incrimination, and you have the right not to answer those questions. However, the counter-argument to that is, of course, that a court may well draw an inference from the refusal to answer certain questions if a person were so summoned, and the lawyers doubtless would be making that argument to the court to say, Your Honour, my Lord, you may well draw an inference from the fact that this witness has refused to answer such a question, drawing on their right not to self-incriminate. But that, again, is possibly one of the reasons why said witnesses are not being brought to court in the first place, along with, of course, the other argument that we've mentioned before, that journalists' sources are to remain secret. and they're not in contempt of court by not revealing their sources. So I thought you would find that an interesting answer to the question. There is more to it, and when we find time to do a joint video, we will probably do this in more depth because it's a very interesting question. There is obviously a lot more to it than that brief summary, but that is a very brief answer to the question. I hope you found that useful. Make sure you subscribe because this is our new and joint channel for art, media and law with myself and Alan Robertshaw. Yes, it rhymes, and I'll see you next time.